Judgment in the matter of Wathen-Fayed against Secretary of State for Housing, Communities and Local Government.
This judgment will be handed down by Lord Hamlin.
Cremation in England and Wales is governed by the Cremation Act of 1902, which I will call the Act. The Act contains provisions which restrict where a crematorium may be sited. Specifically, Section 5 provides that no crematorium should be constructed within 200 yards of a dwelling house or 50 yards of a highway. I shall call these restrictions the radius distances. The practical application of these restrictions depends on what a crematorium is for these purposes, because it is from the crematorium that the radius distances are to be measured. Section 2 of the Act defines a crematorium as meaning, quote, any building fitted with appliances for the purpose of burning human remains. I shall call that the core definition. And adds that this, quote, shall include everything incidental or ancillary thereto, which I shall call the extended wording. The factual context in which this issue arises is a challenge made to the grant of planning permission for a crematorium off the Oxted Road in Surrey. The grounds of that challenge are that the location for the site contravened Section 5 because the radius distances were required to be measured from an area that included a proposed memorial garden in which ashes might be stored. The challenge was rejected by the High Court and the Court of Appeal on the basis that a crematorium does not include an outdoor area to be used for the storage of ashes. The Court of Appeal held that it comprises the crematory and all other buildings or structures on site in which functions incidental or ancillary to the cremation process are carried out. The appellant, Mrs. Wathen-Fayed, appeals against that decision. In its judgment, the Supreme Court unanimously dismisses the appeal, holding that the distances specified in Section 5 of the Act are to be measured from the building which houses the crematory. The judgment is given by myself, with whom all the other justices agree. The extended wording involves wide words. Incidental generally means something which is connected with something else or happens as a result of it. Ancillary generally means something which is additional to or supportive of something else. The core purpose of any crematorium is the burning of human remains. On the face of it, all parts of a crematorium site are there to support that purpose and are connected with it. Such a wide application, however, makes little or no sense in the context of the restrictive purposes of Section 5. In particular, if the extended wording is given its naturally wide meaning, it would include access roads. This, however, results in an absurdity and renders the Act unworkable. It would mean that a burial authority would never be able to connect its proposed crematorium site to a highway because any access road has to be 50 yards from the public highway. The consequence would be that a crematorium could only be built in cemeteries or burial grounds which already had the necessary access roads. That would completely undermine the Act's purpose of facilitating the establishment of crematoria. The presumption against absurdity in statutory interpretation applies. It would also mean that the distance restrictions apply to all uses of the site. It is, however, impossible to see what rationale there could be for applying such restrictions to uses such as landscaping, an ornamental garden, a chapel, a waiting area, a ceremony hall, an access road, car park, or service yard. The solution to the difficulty, and indeed absurdity, of applying the extended wording to Section 5 is to hold that, for the purpose of that section, only the core definition applies. This is supported by other provisions in Section 5. First, Section 5 states that, quote, no crematorium shall be constructed, close quote. The word constructed most naturally connotes a fixed structure, such as a building, rather than merely land use. Secondly, Section 5 provides that no crematorium may be constructed, quote, in the consecrated part of the burial ground of any burial authority. This restriction is understandable in relation to the crematory building, but not for other buildings or land use. It is also supported by the statutory context, since there are other provisions of the Act in which the word crematorium can only apply to a building, such as Section 9 relating to the charging of fees. Further, under Regulation 16 of the 1903 regulations, which at the time of the Act was to have the same effect as if enacted in the Act, land reserved for the burial of ashes is treated as not being part of the crematorium, but rather as land, quote, adjoining it, which is consistent with the crematorium being a building and inconsistent with it including related land use. It is further supported by the purpose of Section 5, which was primarily the protection of public health. This is consistent with the focus of the section being the place where the burning of human remains takes place, i.e. the crematory building, but inconsistent with its focus being other buildings on the site or land use on the site. Further, an interpretation which measures the radius from the crematory building offers certainty. It enables the distance to be measured by reference to a fixed point on a single permanent structure. By contrast, the appellant's interpretation involves measuring distance from areas of land dependent on their use. This is not only far more difficult to apply, but it also makes everything dependent on a variable, land use from time to time. For all these reasons, crematorium in Section 5 of the Act should be held to mean a building fitted with appliances for the purposes of burning human remains. It follows that the radius distances are to be measured from the building which houses the crematory. The appeal must accordingly be dismissed.
The court will now adjourn.